That is without consideration to 6.4.2.1, which is the most important provision when we are looking at the powers under Article 6.4.2.1, because it says, without prejudice to the generality of its powers, the National Council shall. So the powers that are set out under 6.4.2.1 are not exhaustive. And they are without prejudice to the generality of its powers. What does that entail? It entails the power to be custodian of the party in between congresses, to be the highest decision-making body in between congresses, to make decisions in between congresses.
I hear you, Mr. Mpofu, but the difficulty I'm having with the explanation that you give is when you look under K, where it's specifically given the power to fill any vacancy by way of an election caused through resignation, death, or any other cause. It doesn't seem to be giving the broad mandate that you refer to, which you say is under 6.4.2.1. It then limits it under K. That is the difficulty that I'm having.
2 points on that, my lady, is that what is under K is a specific enumeration of powers. But that specific enumeration of powers is without prejudice to the generality of the powers. So K cannot define the extent of the powers because the powers are already broader than it. But it does not end there. My lady, I invite the leadership to consider Article 18. Article 19. This is a general power purposefully set out under the Constitution.
Sorry,
18. When a situation of ambiguity, or there is a gray area, or there is something that can not otherwise that is otherwise not clear, the National Council steps in. It steps in all situations. Its powers are unlimited, and it steps in terms of Article 18.
But that's only in the event of there being a lacuna, or it says if there is an omission or oversight in draftsmanship, or because a body provided has not been established, etc.
Now, my lord, you have 3 provisions which say you can have deputy presidents. And once you have those, and there are some people who think that you may not have deputy presidents, how do you reconcile those two? You reconcile those two by activating the powers of the National Council in terms of Article 19.
Well, to buttress your point, the provision goes on to say where an officer provided for in this Constitution has not been elected or appointed.
Indeed, my lord.
That would suggest that if a deputy president has not been elected or appointed,
Indeed,
the National Council can step in. So that specifically relates to appointments of officers of the MDC.
I'm indebted.
Yes, well, one other question. The meeting held on, I think, 15 February 2018. I think on page 111.
Correct. It is the 15th, my lord.
15 February. Your submission is that it was chaired by Morgan Committee.
My Lord, it is more than a submission. It is an articulation of the fact. It was Morgan Commission who chaired that meeting.
Again, for the sake of clarity, in terms of which article of the Constitution did he convene the national, or who called for the meeting?
Who called or who chaired?
Who called? Who convened? Who convened?
Let me find out if that is set out in the papers, because it's something that I'm thinking might not have been addressed because it was not part of the first respondent's case. But let me just have a look at that.
Yes.
My Lord, let me deal with the issues one by one. The first is that in terms of Article 9.3.1.
Sorry, Article?
9.3.1.
Sorry, you're going a little bit too fast. 9.3?
0.1 H.
9.3.1 H. So on what page?
Page 57. Page 57 of the Constitution, my Lord.
9.3.
The role of the chair is to chair Congress, the National Conference, and the National Council. That is what the Constitution says. That is what the minutes say happened. Secondly, the meeting of the National Council is convened by the Secretary General. The Secretary General during this period was Douglas Togarase Munzo. It was Douglas Togarase Munzo.
Sorry, so who convened the meeting?
It is convened by the Secretary General and chaired by the chair.
So you are saying the meeting of 15 February was convened by Douglas Mojora, the Secretary General?
That is correct, my Lord.
That appears where in terms of the powers of the Secretary General?
Pardon, my Lord?
You say the Secretary General. He was Secretary General at the time.
Yes, correct.
He convened.
Not only that, at page 116.
No, in terms of which power? Which provision in the Constitution? Well, as Secretary General, presumably.
It is Article 9.5.
9.5?
9.5.
Yes.
Yes, I can see in Article 9.5, but where does it say he convenes the...
That is the one that gives the power. The one that says the meeting was properly convened is the page 116. Page 116, my Lord, my Lady. Page 116, paragraph 4. Administrative issues on the meeting. It was confirmed that adequate notification had been made to all members through the normal communication mode used to always notify members of the National Council. My Lords, you will note, and my Lady, you will notice two things. Number one, during the meeting, there was no objection to the manner in which the meeting was convened. After the meeting, and in the founding affidavit, and in all the affidavits, there is no objection to the manner in which the meeting was convened. You will then notice my Lords and my ladies, at page 111. Article 1.3 or paragraph 1.3, Article 1.3. That Douglas Togarase Munzora, as the Secretary General, was also in that meeting. All 1.3, my lady.
111.
At page 111.
So just reverting to the powers of the Secretary General, I don't think there's anything specific. What is it, 6 point, which article is it? 9.5. That specifically deals with the power to convene National Council meetings.
National Council, my lord, in A.
In A.
In A. And he's the one who would
organize the meetings. Organize.
But my lord, I need to emphasize the point that on these papers, the manner in which the meeting was convened is not an issue. It was not challenged. It was not an issue for determination at all.
We also noticed that on page 116, under paragraph 4, it indicates that the meeting was convened prior to the death of the late Morgan Changirai.
Correct, madam. So it is a meeting that had already been convened, and they allowed the meeting to proceed in the manner in which it had been convened. In fact, they actually agree that because it had been convened prior to his death, it could not be cancelled simply because he had unfortunately passed away.
So your submission, in essence, was that the meeting wasn't orchestrated or controlled by the second appellant.
It was never, and the finding of the High Court to that effect is without a basis.
Thank you, Advocate Mpoko. We propose to take a 20-minute adjournment, after which we will reconvene and hear counsel for the first respondent. Court will adjourn.